Thank you, Sonia. When last this matter served before me, it was postponed to a provisional date, that is 16 April 2019. I had refused the application by accused number 1 and 2 for my recusal and for the quashing of the charges they are facing. Following that, I refused the resulting application for leave to appeal, culminating in accused number 1 and 2 petitioning the Supreme Court of Appeal, but without success. Subsequent thereto, a conference involving the parties' legal representatives and myself was held at my chamber on 4th February 2019 to discuss the future conduct of the case. At the conference, I was advised by Mr. Doberman of his client's dissatisfaction with the decision of the Supreme Court of Appeal and their quest to petition the Constitutional Court. During discussions that ensued concerning provisional dates to which the matter could be postponed, pending the outcome of the Constitutional Court decision on the matter, Mr. Ntelwa, the state legal representative, addressed Mr. Doberman. He informed Mr. Doberman that it had come to the attention of the prosecution that some witnesses for the state had been accommodated at a guest house in which I have financial interest. I viewed that in the backdrop that at the request of the state, I had excused some of the witnesses who had been subpoenaed due to the time taken by Ms. Zondi on the witness stand. Mr. Ntelwa added that this fact was cause for concern and that if the defense team was privy thereto, they had better amend their Constitutional Court papers to include this fact and thus afford the prosecution the opportunity to deal therewith. Nothing beyond this point eventuated at the meeting. After the conference and upon reflection on the prosecution's revelation and regard being heard to what follows hereunder, I took a decision to merimoto recuse myself from presiding in this case in the interest of justice. This decision was informed by Article 13 of the Code of Judicial Conduct, adopted in terms of Section 12 of the Judicial Service Commission Act 9 of 1994, which in part reads, I quote, 13 Roman figure 4, if a judge is of the view that there are grounds for recusal, but believes that there are facts which, if known to a party, might result in an application for recusal, such facts must be made known timeously to the parties, either by informing counsel in chambers or in open court, and the parties are to be given adequate time to consider the matter. 13.5. Whether a judge ought to recuse himself or herself is a matter to be decided by the judge concerned, and a judge ought not to defer to the opinion of the parties or their legal representatives, close quotes. I thereupon requested my secretary to invite counsel to my chamber, and they eventually gave heed to the request at 16 hours on 6 February 2019. On this occasion, the prosecution was represented by Mrs. Fontaine and accused number 1 and 2 by Mr. Doberman. I declared my intention to recuse myself to the legal representatives, adding that my reasons, therefore, would be handed down in open court on 15 March 2019, hence our convergence here today. Let me at the outset place it on record that I am not involved in any company or legal entity, either as a director or shareholder. It is indeed so that my wife operates business ventures, including a guest house in which she holds shares through a registered closed corporation of which she is a sole member. I have no financial interest and play no role in its affairs. Purely for the sake of caution and completeness, and in accordance with the conditions of my employment, I have declared to the Office of the Chief Justice my wife's business interests through the legal entity from the year of its information, from the year of its formation, and continue to do so on an annual basis. It is concerning that the media has reported me as having been requested by Mr. Doberman to recuse myself. I assume in Mr. Doberman's favor that he is not the source of the report. The media has further referred to a letter addressed to the Office of the Director of Public Prosecutions as the basis for such information. The information is not correct. A judge is precluded from corresponding directly with legal representatives appearing before him in a matter. I further place it on record that the letter has nothing to do with my office and presume that it was correspondence between the parties' legal representatives. Having put the record straight, and whilst I am of the view that there are no grounds for me to recuse myself, reference to some state witnesses as having been accommodated at a guest house in which my wife has financial interest is a factor which might reasonably give rise to an apprehension of bias and result in an application for recusal being brought. I interpose here too and mention that I am not privy to the information held by the state concerning the accommodation of the state witnesses. Despite that fact, there is no application for me to recuse myself based on this fact, and independently of the opinion of the parties or their legal representatives, I am of the view that the appropriate thing to do is for me to recuse myself, which I hereby do. The future conduct of this matter will be determined by the Judge President with the parties involved. At this point, the court will adjourn for a few minutes while I pave way for the Judge President to take over. Court shall adjourn.
We're going to have to be very quick because the judge is going to walk in, right? No, we're going to have to be very quick. Yeah, come please. Okay, come to me. Come to me. Yeah. One, two, one, two, one, two, one, two.
And it's crushing the meat well. saying that Judge Makaula is the one actually pressing that on the issue of using government.
Can come to us now.
Giving the information that giving information that
Yes, that is indeed correct, Desiree. The judge has recused himself, but quite interesting revelations that came out of the reasoning why. Him saying that the establishment was actually owned by his wife. She is a businesswoman here in Port Elizabeth, and she was the one who actually owns the establishment. He also made mention of the fact that he did not appreciate the way the media had handled the situation, and that also alluded to the fact that he wondered if Peter Doberman was the one who actually told the media that this was the case. So he questioned that a lot, but really saying that he is stepping down for the interest of justice, and that he is stepping down and allowing justice to prevail, and he is not biased, and therefore he will recuse himself, but rather coming out there strongly saying and making mention of the fact that the establishment where Cheryl Zondi was staying here in Port Elizabeth is not in his name. He has no affiliation with it, but it is owned by his wife, Desiree. I'm also told that there will be another judge that's going to be walking into the courtroom very, very soon, and he'll be presiding over the matter. I'm not sure if Omotoso's legal team has something else to make mention, or if the state prosecutor Nlebe Ntewa will actually oppose this decision by the judge. But I suppose once that judge walks in, we'll get more of an indication what happens now after Makaula has officially recused himself. Well, I imagine that the new judge that's going to be appointed will obviously come in and introduce himself and preside over the matter today. We do not know yet if this is going to be the judge who's going to preside over the entire trial. You would know that the trial will start on the 16th of April. This was a short break just to have the defense lawyer, Peter Doberman, send that application to the Constitutional Court. You would know that that application was continuously ongoing, regardless of the fact that Makaula has decided to recuse himself. So right now we're a bit sketchy with the information as to what will happen now, whether the judge will actually preside over the matter, the new judge that's going to be walking into the courtroom very soon, or if there will be another judge appointed. But Desiree, I'm also going to step out of shot and just, if Mcebisi can show you, we also told that Nathi Mncube, Chief Justice spokesperson from the judiciary, is also present in court today. So I'm going to try and speak to him and find out where to from here, and also find out how exactly does the NPA and the Hawks find establishments for the witnesses, because I think that most South Africans are wondering why did they not know that Makaula's wife actually had shares or owned this establishment here in Port Elizabeth. Desiree. Well, now the trial is de novo. That means that the trial will have to start from the beginning. So Cheryl Zondi will unfortunately have to come back to the stand, and she will have to go under cross-examination once again, Desiree. Stay up now. Stay low.
The sound from the yes.
Rise report.
As your Lordship, this is my wife, complaint case number 60/2018, the matter between the state versus Timothy Omotoso, Lusanda Sulani, Zukiswa Situ.
We are in a position now where
we are appearing for the state.
oh, thank you, Mr. Yes, I'm very good.
May it please your Lord, I appear for all three accused in this matter.
Thank you, Mr. Donovan. Yes, Mr. Dino. And the parties argued that in light of the recusal by my brother Makaula J, the matter will commence de novo.
We are in detail.
Yes. Mr. D.
I confirm that, my Lord.
Yes, Mr. Dino.
We are looking and we did discuss between us that the second term will be good for both parties, that they start on the 30th of July.
Third term, eh?
30 years.
Yes, that term commences on the 29th of July. However, there's a judges meeting on the 29th, which therefore takes us to Tuesday, 30 July. Is that the understanding?
That is the understanding.
And what is the estimated duration of the trial from your camp's perspective?
My estimation, Melody, is I might need about 2 months for the state case. 2 months, that's to be 8 to 9 weeks.
8 to 9 weeks. That then takes us right to the end of the third term and possibly into recess, otherwise a week into the fourth term. Is that the understanding?
That's the understanding, Melody.
Yes. Yes. Mr. Doberman, is that the understanding?
That's my understanding too.
And is it so that this trial, once it commences, it will run to completion?
I understand that is the position, that is your ruling in fact.
Yes. Yes.
Might I just inquire whether the court will be sitting in the recess as well, or will we commence on the first day?
Not necessarily so. We move from the premise that recess is not vacation, but it might very well be that for some other reason the case may not proceed during recess. Hence, I addressed the parties in the manner in which I did, that the third term has got 8 weeks, if I remember well. And if the estimated duration of the trial is 9 weeks, then it's either it will spill over to recess, failing that, fourth term.
As your Lordship please.
So it's in that context.
I understand now, thank you.
Thank you. And then maybe there are a few preliminary issues that we should deal with. Are there any anticipated in limine or preliminary applications to be brought?
Lord, I've been advised by my learned friend that he intends proceeding on the same charge sheet as before. So, in all likelihood, I will raise the same objections to the charge sheet in limine. That is the only anticipated in limine application from my side. Thank you.
Yes. What about the involvement of the media? Was there at any point in time an understanding between the parties as to the involvement of the media and the extent thereof?
My Lord, what actually occurred is that on the first day of the trial, the parties were advised by your Lordship's brother that he had been approached by the media and that he had granted them permission to televise the proceedings live. And he inquired whether we had any objection.
And there was
to
none.
that. I did. There was no objection, yes, ma'am. But I must say that at this stage, I'm going to request that the proceedings not be televised live the next time around. And the reason for that, my lord, and I can just place this on record, is that in a criminal trial, witnesses are not normally allowed to sit in court and listen to other witnesses' evidence.
Yes.
And the effect of broadcasting the proceedings live is to allow witnesses to hear what the other witnesses are saying. So I'm not trying to muzzle the media in any way. They are entitled to be present in court and they can report at will on the proceedings. But I'm going to object to the live broadcasting of the proceedings for the reason that I've mentioned.
Yes. You're just indicating at this point,
yes,
but it's a matter that will be raised with,
yes,
with the court hearing the matter at the opportune
yes,
stage.
Lord. I think the proper procedure is for the media to make an application to the new presiding judge to be allowed to televise the proceedings live.
Yes.
And in the event of such an application, my clients are going to oppose that application for the reasons I've mentioned.
Thank you for your
Thank
transparency. Mr. Dilwa?
Thank you, my lord. My lord, in regard to the issue of the media, may I defer my submissions until later, because I have to consult the witnesses and the head of the MPA about the issue. So I'm not in a position.
So it would actually be convenient for the media to indicate its stance timeously long before the hearing, so that if there must be some form of submissions to be made by the parties, then written submissions can also be delivered.
Yes, I think that's a wise course of conduct. So the trial will not be
before the trial
delayed.
Yes.
So I would suggest that if the media wants to broadcast the proceedings live, they must make a proper application in due time, long before the trial date. Thank you.
Of course, they are not parties to these proceedings to the extent that they may be here in court. I guess they are all ears. Thank you.
They're definitely all yours. Thank you.
Mr. Ntilwa, there won't be any substantive application from the state side?
None from the state side.
Mr. Doberman,
Yes,
as I understand it, accused number 1 is in custody,
I confirm that.
and accused numbers 2 and 3 are out on bail.
Yes, Lord. I would request that accused 2 and 3's bail be extended on the same conditions as before.
Thank you.
Thank you.
Any further points to make?
None, my lord.
Thank you very much.
Because on the last occasion, the recusals for accused 2 and 3 were delayed. In so far as according to the police station, but since they are here, they were released by the previous officer. So may that remain.
Shall we take a short adjournment until thank you. Now we have so I think Before you come to the speak with typing skills,
Kam. Bengicala kam. Becala madoda. Huh?
Did not arise when last I was here.
Yes, something that I feel I should mention now.
Yes.
Your Lordship may or may not be aware of the fact that there are 21 female complainants in this case. And the defense wishes to propose, in the interest of fair play, that a trained psychologist stand by each of these complainants when they give evidence here in court. We make that proposal and we would have no objection to the witnesses being assisted by a trained psychologist here in court, supported by a trained psychologist, at state expense, of course. If my learned friends for the state wish to make those arrangements, they're welcome to do that, and we will have no objection to that. We feel that it's only fair that they should be assisted by a trained psychologist in the matter when they testify. Not with regard to the evidence, but just by way of support in the witness stand.
I take it that those are matters that the parties can deal with amongst themselves.
Yes, you're not required to make any order in that regard, Lord, but I'm just placing that on record now for what it's worth. Thank you, Lord.
Mr. Mpuma, I take it that you may not wish to respond to that.
Not now, indeed, Emperor.
It's something that you may need to
Discuss.
heed to. So what remains is for me now to grant an order, mapping the way forward in this matter, which is what I will do right now. The case is postponed to Tuesday, 30 July 2019, on which date the proceedings shall commence de novo. The trial shall run from that date through the 3rd and 4th terms, if it comes to that, until completed. Any of the parties hereto desirous of bringing an application on any related preliminary issue shall issue notice of intention to do so on or before 28 June 2019. Accused number 1 will remain in custody. Accused numbers 2 and 3 will remain out on bail on the same relaxed terms as have been applicable up to this point. Court Chair.
Microphone.
You see, this thing is historic.
Face for